Hello and welcome to AWCI's webinar, Navigating the 2026 Regulatory Surge, Key Compliance Issues for Employers. My name is Anne-Marie Silvatelli. At this time, I would like to introduce our presenter, Kara Maciel, who is founding partner of Kahn Maciel Carey and chair of the firm's National Labor Employment Practice Group. Being located in Washington, D.C., Kara provides a unique perspective to international and multinational corporations on doing business in the United States from a federal statutory and regulatory perspective, as well as compliance with a myriad of state and local business requirements. She has also advised employees and companies on allegations of whistleblowing, False Claims Act, and other whistleblowing protections. With this, welcome, Kara.
Thank you, Anne-Marie. I appreciate the opportunity to present to your members today. 2026 is going to be a record-breaking year, exciting year from a regulatory perspective. And so there's a lot to talk about, and really do welcome people's questions. Happy to answer them as I can throughout the presentation, but also, as Anne-Marie said, we'll have a Q&A session at the end. So let me kick off and kind of tell you what our plan is, the agenda is for the day. And I just want to make, okay, there's my bio. Here's my contact information, which is included in the materials if anyone wants to contact me after today's presentation. But here's kind of the agenda for the day. I'm going to start to talk about the federal EEOC, who they are, what their priorities are, and some specific initiatives that the commissioner has outlined, and what we anticipate to be a pretty heavy year from the EEOC. Then I'll turn to the Department of Labor and talk about some of their initiatives and things that you should be mindful of and implementing. I'll talk also about the future of federal labor law from the National Labor Relations Board. That is an agency that is now back to business after being stalled for most of 2025. And to the extent that we've got some time, I'm going to close just with a summary of sort of what's happening from the executive level for the administrative agencies, and how the president has been reshaping the state of affairs from the agencies, and what we expect to see from that, and potentially inquiry from the Supreme Court on that topic. So without further ado, let me jump right into the future of the EEOC. The EEOC has 5 commissioners, up to 5 commissioners, and a general counsel. The chair is Andrea Lucas. She joined the EEOC in 2020 as a commissioner. And very shortly after President Trump became president last year, he made her the acting chair by firing several of the other commissioners. At that time, it was just really Chair Lucas. And so without having a complement of at least 3 commissioners sworn in, the EEOC was pretty much at a standstill. So there was Commissioner Kotagal, who was a democratically appointed commissioner. She was appointed in 2023 by President Biden. So she and Andrea Lucas, again, for most of 2025, were at the EEOC together, but really couldn't effectuate any strategic initiatives until another commissioner had been nominated. That happened in October of last year, when we got Brittany Panuccio as commissioner. She joined, and that created a 3-member majority of the 5 and allowed the EEOC to implement its priorities. In addition, we have Carter Crow as the general counsel. He was nominated in November of 2025, and he really is the attorney who prosecutes the enforcement actions that the EEOC can take. So the EEOC can issue rulemaking, opine about different initiatives, but if they want to step in the shoes as a litigator, as a plaintiff, suing employers for violations of the myriad of laws that the EEOC enforces, primarily Title VII and the Americans with Disabilities Act, it would be the general counsel would be the one directing the agency on those types of initiatives. So with that as a framework of who has been nominated and who's at the helm of the EEOC, we did hear from Andrea Lucas while she was the acting chair as to what her priorities would be for her tenure. She has highlighted rooting out unlawful DEI, that's diversity, equity, and inclusion, motivated race and sex discrimination issues with employers. She has talked about protecting American workers from anti-American national origin discrimination, religious bias and harassment, including anti-Semitism, defending the biological and binary reality of sex and related rights, including women's rights to single-sex spaces at work, really stepping into the issues of transgender accommodation in the workplace, and then other areas of under enforcement. So from the get-go, we knew these were things that Chair Lucas would want to be focused on, and we really expect and have already started to see a lot of these initiatives start to take place and flesh out a little bit more with some recent guidance from the EEOC. In particular, the EEOC and the Department of Justice has issued joint guidance on DEI programs. And what they say is that DEI practices may, and I emphasize may, be unlawful if an action is motivated, even in part, by an employee's protected categories. So for example, if an employer seeks to maintain a diverse workforce in terms of age, race, national origin, and sex, and advances those factors by recruiting for those groups, whether it's, from associations or from colleges, focused on women or people of color, that employer, under the new guidance from the Department of Justice and EEOC, may be advancing unlawful DEI programs. So really what this guidance says is it's pretty much a strict restriction on how you can implement DEI programs under anti-discrimination law. Now I get a lot of calls about this topic over the last year, and that's not to say that every single DEI program is automatically unlawful. Title VII has been around for a very long time, and Title VII has always said that if you consider, an employee's sex or religion or their race or their national origin in any hiring decisions, any adverse employment actions, that's going to be unlawful. But what the scrutiny now is focused on is there an advancement? Is there a preference for hiring or recruiting, again, from various agencies that has a focus on minorities, primarily minorities and people of color? I think will be the focus of this agency on those types of practices. We saw it earlier in the year, and I do think that is going to continue. I think employers that have practices who have, even affinity groups that meet, those are not unlawful so long as people are not excluded from attending certain affinity groups and that it is open to all. So that I think is a primary focus of the EEOC going forward. The second issue that she mentioned was about national origin discrimination. And recently in November, the EEOC released a technical assistance document to clarify their enforcement priorities for national origin discrimination. And what this really is about, again, protection for all national origin groups, which include Americans, primarily from the EEOC's perspective, and that employers cannot treat applicants or employees more or less favorably because of their national origin, ethnicity, accent, or perceived background, even if that perception is incorrect. So for example, if you are preferring foreign workers, including visa holders, over US workers, the EEOC says that is unlawful under Title VII. Even if you have, legitimate business reasons, particular lower labor costs, preferences, productivity, those types of rationales do not justify national origin discrimination. And so one of the things that I'll talk about in a second is the importance of reviewing your hiring practices to ensure that there is not, either through your job applications or otherwise, there's not some affinity towards non-American, non-US workers. Some of the examples of unlawful practices that were listed in this guidance include a job ad or application saying that H-1B visa are preferred, or H-1B visa holders only, Those are special visas that recruit specialized workers from foreign countries. If there's some sort of disparate treatment where you're imposing more burdensome application processes on US workers or terminating them at a higher rate than visa holders, any type of pay discrimination or harassment, retaliation, again, based on national origin. We are seeing a lot of partnerships between the agencies, as I just mentioned, with the Department of Justice on the DEI. We are similarly seeing the EEOC partner with the Department of Labor under a program called Project Firewall, which the agencies will share their data and coordinate enforcement, particularly in industries that use high foreign labor. So be mindful and expect that if there is an investigation, it will involve multiple federal agencies, including the EEOC, the Department of Labor, Department of Justice, and Homeland Security. So some things you should be doing now to ensure that you don't run into the crosshairs of those agencies on national origin discrimination. Certainly review all of your job postings, making sure that there isn't any language in there that is preferring visa holders or somehow, discourages applicants based on their national origin or visa status. You want to update your policies. This is something that I'm going to say throughout the presentation, but every agency will be looking at your policies and procedures during any type of investigation. And now is the time to proactively review and making sure that your handbook, that your other policies and procedures are up to date and that they are consistent, across the protected categories and explicitly prohibits national origin bias and retaliation. You want to look through your process for hiring and recruiting and screening applicants, again, so that there's no concern of an unequal process between US and foreign workers. This is a good time to train and retrain your HR team and your managers who are involved in the hiring process so that they understand what are the right kinds of questions they should be asking, what type of information they should be screening, again, reinforcing the Title VII protections and banning stereotypes. Because the EEOC is focused also on pay transparency, this is a good time to do an audit of your pay and promotion practices to confirm neutrality and making sure that any promotions are based on job-related reasons. And then finally, the importance of documenting decisions, whether that's through the recruiting and hiring and selection process that you're documenting which candidates are being selected for an interview, which candidates are being selected for a job offer, and then throughout the employment process, clearly documenting any employment related reasons, whether that's discipline or termination otherwise, so that upon investigation, the EEOC can make clear that all decisions were made for a lawful reason and not for an impermissible discrimination reason. The other thing that the EEOC is focused on is religious accommodation requests. They are aggressively enforcing Title VII obligations, particularly around religion. We saw religion requests take a much higher view during COVID when people were using religion as a reason not to be vaccinated. I think since that has stemmed, we've seen lesser religious accommodations, but I anticipate in 2026, employers will be receiving a lot more religious accommodation requests, particularly as it relates to not working on certain days due to the Sabbath or because of attending church services, or things of that nature. The definition of religion is very broad under Title VII. It includes the traditional faiths, but also non-traditional beliefs that are sincerely held, even if it's not, part of an organized sect. Importantly, social, political, or personal preferences are not protected. So if someone says, I don't want to work, on Friday night just because I don't feel like it, that's not protected. But if someone says, I don't want to work Friday nights because I recognize the Sabbath, that should be something that should be accommodated. So you really should assume sincerity unless you have an objective basis to question it. Again, some type of inconsistent past behavior, suspicious timing, something evidencing, non-religious motive. Some examples, as I mentioned, of a reasonable accommodation that you might start to see more of, again, alternatives to vaccination, masking, regular testing, telework, and reassignment, flexible scheduling for attending religious observances, modification to dress and grooming policies. You are able to deny a request if granting the accommodation would cause an undue hardship, but undue hardship is really a substantial burden on your operations. It's not just a de minimis cost. And so certainly before denying a reasonable request for an accommodation, whether it's religious or otherwise, it's important to speak to counsel, make sure you've done everything you can to evaluate the undue burden hardship and before making that decision. I will also say that another type of religious accommodation that I anticipate seeing is a little bit of a conundrum in the workplace between someone who is transgender and wants to use certain pronouns or have their coworkers use certain pronouns, and another coworker says, I object to that. I'm making an accommodation that I do not have to use that person's preferred pronouns because my religion, informs me that that is not appropriate. And as a result, my religion teaches me that it's either a man or a woman. I anticipate a lot more of those types of tough questions happening in the workplace. Similarly, the use of a single-sex bathroom. So as those come in, it's important again to train HR and how to review those requests, how to work with managers on responding to such requests, and ultimately making sure that any denials of requests are held appropriately in accordance with the law. The future of the Department of Labor. So the Secretary of Labor, Chavez de Ramey, she is the secretary. She was confirmed pretty quickly in the spring, in the winter of 2025. Keith Sonderling was confirmed as her deputy secretary. Keith Sonderling has a lot of experience in the federal agencies. He worked in the Department of Labor under the first Trump administration. He has also worked as a EEOC commissioner, so he understands the administrative state and regulation and how things move. The secretary comes from Congress. She was a House member of Congress. And so the two of them are really embracing what it means and moving forward the Department of Labor. The Department of Labor, unlike the EEOC and unlike the Department of the National Labor Relations Board that I'll talk about, they have been fully functional since January. And so they have continued to move forward with their agenda. Two main topics that we have heard that they will be focused on are rulemaking on independent contractors and joint employers. And I think this has been topics that the department has revisited over the course of several administrations, often going back and forth on, who qualifies as independent contractors under the FLSA, and what the current administration is saying is they're going to really eliminate the Biden era rule over who is an employee versus who is an independent contractor. So they're going through kind of a more appropriate and reasoned independent contractor classification. That is likely going to be a reduced factor test as opposed to the 6-prong test, economics reality test that was under the Biden administration. This could be welcome news for employers because a lot of, particularly in the construction industry, there are a lot of independent contractors. And so having a better clarity over how to classify those workers, I think will be a welcome relief from the business community. The second thing that they're going to talk about is who are joint employers. If you are a subcontractor working with a prime contractor on a construction project, how is that relationship, and at what point do both companies are held equally liable for the employees of each other's companies under a joint employer construct? Last week, I heard that some guidance is being escalated through the federal agency to the Office of Management Personnel. There wasn't really any specifics over what the guidance said, but again, we think that there will probably be similar rulemaking from the first Trump administration in terms of this balancing test to determine when employees are jointly employed by more than one business. So stay tuned, but know that those are two very important areas that we expect to see guidance on from the Department of Labor. Otherwise, we're seeing the department, enforce just as it has had, over the last many years. Even though they've got reduced compliance assistance, they have almost a $25 million reduction in their funding for the wage and hour division. The wage and hour division enforcement activities will continue. Just last week, the agency released a press release that it has recovered over $250 million in back wages under its enforcement efforts just in 2025 alone. And so they are still looking at issues of worker misclassification, working off the clock, other similar overtime issues that is prevalent in hourly industries. And so making sure that you're still following that and doing those audits is important to making sure that you stay out of a wage and hour enforcement. I will note that one of the good parts of their enforcement is that they have issued a bulletin that they are no longer requesting liquidated damages in a pre-litigation investigation or resolution. So what that means is that if there is an investigation and they find back wages, they will just seek back wages. They will not seek a double amount of that amount for liquidated damages if employers are able to resolve those pre-litigation. And I do think that type of compliance assistance for employers is important. And one area that we're seeing the department move for advising employers to make them help them understand what is, how they can comply with what is a really challenging statute, I think, in the Fair Labor Standards Act. One of the things they did is they expanded this opinion letter program. And that had gone away, but they are now reopening and reissuing opinion letters really to help employers provide really meaningful compliance in understanding how to navigate the law specific to their unique workplace. And so if you do have an issue where you're finding confusion or you're working with counsel, you're doing an audit and you think there might be a compliance issue, the department, welcomes an opinion letter, and you can send in a letter to the department and ask them for their specific opinion about how this impacts your workplace, again, to address the real world questions and to promote clarity and consistency. Last week, we saw this come to fruition where the Department of Labor issued 6 opinion letters. I won't go through all of them. You'll have the materials with you following this presentation, but they spanned the issues of, how does someone become exempt under the learned profession under the FLSA, and what to do when you reclassify them. For people who, have incentive bonuses or incentive payments, how do you exclude those bonus payments from a regular rate of pay? How you calculate overtime in that circumstances. This is true in union and non-union workplaces, but in the third opinion letter, this happened to be a unionized workplace. And the question is, if there is a mandatory, 15-minute roll call before each shift in which the supervisor is going through, the priority issues of the day before the shift actually starts, is that considered compensable time, or is that excluded under the FLSA from overtime? For industries that have commissioned workforce, there's a question about how you apply a 7I, which is an exemption from overtime. That was something that they opined on in terms of if you're in a state where the higher state minimum wage is higher than the federal minimum wage, how do you calculate the regular rate of pay? And then there were 2 opinion letters clarifying issues under the FMLA, which is another area that the Department of Labor opines on. So again, this is a real life example of how the Department of Labor is being more focused on compliance assistance and helping employers navigate questions that may arise rather than, seeking immediate enforcement through an investigation or otherwise. So the third agency I want to talk about is the National Labor Relations Board, which enforces the National Labor Relations Act. And at a very high level, 10,000 view, is important to understand that the National Labor Relations Act applies across industry, across companies in the private sector for both unionized and non-unionized. So if you are non-union, do not, poke your head in the sand and think that this doesn't apply to me at all. It equally applies with force, and it's even more important to understand what your role is as managers and supervisors and what your employees' rights are under the National Relations Act. In particular, all employees have the right to engage in protected concerted activity regarding terms and conditions of employment. This could be something as easy as a group of employees come together and hold a meeting with their supervisor to talk about their wages, or to talk about changes in their schedule, or to talk about the tools that they need to be able to complete their job function. Any kind of group activity that is talking about working conditions, that is considered protected under the Act, and an employer cannot discipline or otherwise retaliate for engaging in that kind of activity on behalf of employees. We're seeing a lot of protected concerted activity occur in the social justice front in the last year or so, where people are engaging in walk-offs because of social justice issues, or we saw a lot happening with the war in Israel. And so that also is something that could may be potentially covered by the Act. Certainly any kind of union activity is protected. That's the ability to form a union, join a union, assist others in joining or asking questions about a union. And then, as I mentioned, prohibits discrimination or retaliation based on either activity, union activity, or an employee's protected concerted activity. And then to the extent that you are a unionized workplace, the Act requires you and a labor union to bargain in good faith over terms and conditions of employment through a collective bargaining agreement. So with that, let's kind of go directly to the board, the National Labor Relations Board. Like the EEOC, it is a 5-member board. The members are appointed by the president and confirmed by the Senate. And in January of 2026, almost immediately, the President Trump fired several members of the board, including member Wilcox, which left the board at that time without at least 3-member majority. And so it was really, there was a chair, his name was Marvin Kaplan, and David Prouty were the only 2 members left of the board. Member Wilcox challenged her termination through several lawsuits. Those cases have made its way through the district court, through the appellate court litigation. Ultimately, it was not on the merits, but it was ruled by the Supreme Court that she could be removed. Her removal can stay while she's litigating the merits of her removal. That the Court of Appeals in DC has recently affirmed on the merits her removal. So I have her on the slide just to say there was a lot of litigation over whether the president could terminate the board's member under his authority. But anyway, more recently, we finally got 2 new members. Member Kaplan, his term expired in August, so we were without a chair. But in the fall, we recently, just in December, have a new board, and that is led by James Murphy. He is the chair. He comes from the board. He's worked for the board as an attorney for most of his career. So he has a really long-standing history and knowledge of how the board works, how the players, interact with each other, how to do rulemaking, how to adjudicate cases. He's really long-standing knowledge of board and board precedent. He is joined by Scott Mayer, who was also recently confirmed at the same time. Scott Mayer comes from Boeing. He was a chief legal officer for Boeing that handled a lot of labor relations. So he has good experience from the business community, understanding how the board and how the National Labor Relations Act impacts businesses at a real company level. And I think he will bring that perspective to him when he is evaluating cases from the board. And then we still have David Prouty. His term expires later this summer, which again will leave back to 2-member. So hopefully we'll be able to get another member or David Prouty as a Democratic member, they may choose to renominate him. I don't know, but that's where we're at. And because of that, we are now starting to see really very soon a lot of the backlog in the cases that have been building up over the last year when the board was not at its full complement. So we expect to see a lot of activity coming from the board right now. I think some things that we anticipate to see happening in terms of changes will be welcome from the business community. There was one case that came out that talked about a decision that required employers to recognize a union without an election if certain conditions were met, or when unfair labor practices were occurring after a demand of recognition. That's called the CMEX decision. And that is still the law of the land, although the board, we hope, will find an opportunity to reverse that decision, really with the idea that they really are focused on union elections happening by election, and not through other non-election ways, whether through recognition or again through this order under CMEX. We also hope to see cases restoring the ability of employers being able to speak about their business and about whether an employee should choose to become union or not union. There have been a lot of restrictions on employer speech from the board in the prior administration, so we're hoping to see a case that overrules that and allows employers to be able to have direct communication with their employees about whether or not to become unionized during a union campaign. There also was a decision that impacted all employers, not just unionized employers, that prohibited severance agreements with hourly employees that included confidentiality and non-disparagement provisions. So as we've seen a lot of reductions in force occur across the country in different industries, often as part of a reduction in force, an employer will want to provide some type of severance in exchange for release of claims. In those release agreements, it's often in the employer's interest to have confidentiality about the terms of the agreement or about their employment, and a promise that the employee will not disparage the company after they leave employment. The board found that to be intrusive on an employee's willingness and ability to speak about terms and conditions of employment, which is part of their Section 7 rights, and to engage in protected concerted activity. So the board found those to be unlawful and unfair labor practices. And so hopeful that the board will restore an employer's ability to include those types of provisions in a standard severance agreement. And then, as I mentioned earlier, the importance of handbook rules and making sure that your handbook is up to date with the current state of the law. The board equally has opined over the last several years on a variety of different type of handbook policies, such as confidentiality, such as recording in the workplace, whether that's recording by video or recording by audio, dress and grooming standards. The board has implemented various standards scrutinizing these types of policies and procedures, and we're really hoping that the board pulls those back and allows employers the freedom to implement lawful policies appropriate for their workplace without restricting that due to a perceived Section 7 right. So those are some big topics that we anticipate getting from the board in terms of prior case law. Another new addition to the board is a new general counsel. Her name is Crystal Stowe-Carey, and just kind of like the general counsel of the EEOC, General Counsel Carey will be the person really responsible for investigating and prosecuting unfair labor practice cases, both in the regions. So the board is made up of a number of different regions around the country, some just one in one state. There are several in different states, and she directs those regional directors to look for cases in which would be good to either reverse the case law I just talked about, or find other areas of priority in terms of prosecuting cases and unfair labor practice charges. She has had a long career with the board. She started as an attorney in the Baltimore regional office. She then moved to headquarters and worked in enforcement litigation. She also was a staff member to former chairman Phil Miskamara under the previous Trump administration. She's been in private practice at Morgan Lewis and now was recently nominated and confirmed and will be working with the board members to move forward its mission on reversing some of that precedent we just talked about. So with that, I want to make sure we have got some time for Q&A. I want to kind of close with talking about the future of the administrative state. As we've talked about just today, right? The federal government, the executive branch, is made up of a number of different federal agencies. We just talked about the EEOC, we talked about the Department of Labor, we've talked about the National Labor Relations Board. Though also includes the FCC, the FEC, a lot of federal agencies. And this administration entered its second term, with a philosophy of what's called, executive action, and what it terms as really decreasing the role of federal agencies and allowing more of that control to be embedded in the executive function of the administration, of the president. And we saw the president execute some of that by terminating members of these commissions. They terminated some EEOC commissioners, terminated member Wilcox from the board, and saying, I as the president have control over who should be named in these agencies, whether they're independent or not, and really, again, centralizing the control over the singular focus of the executive, of the president. And that was really bolstered by a Supreme Court decision that overturned Chevron versus National Resources versus Defense Council. And this was the Loper Bright Enterprises case versus Raimondo. And what this case started a kind of domino effect of Supreme Court decisions that basically said, look, it is the courts, the judicial court function, to interpret statutes that are passed by Congress. It's really not agencies that should be. Chevron really allowed for a lot of deference by these agencies to say, look, I'm the one who's the most knowledgeable about this particular subject matter, whether I'm the EPA and I know environmental statutes, or I'm the Department of Labor and I know the Fair Labor Standards Act. So I should be able to implement rulemaking or otherwise defer, have deference over how I want to interpret the statute. And what the court said in Loper Bright is, and particularly from Chief Justice, says, in the business of statutory interpretation, if it's not the best, it's not permissible. So we will start to see, to the extent that there is any rulemaking coming from these agencies, more explicit support in the statute itself for why that rulemaking is important for different standards and regulations. We'll also probably see more legislative action required. Again, increased litigation over how an agency is going to be interpreting that from the courts, and also, expecting to get more statutory construction and historical record as to what a statute means, rather than just coming from the agency. With respect to policymaking, we expect to see a slower response to particular issues because of this new standard and lack of deference. So the second Supreme Court case that came out in June is the SEC versus Jarchese. And what that basically focuses on is the company's right to have a jury trial in an agency enforcement action. The Seventh Amendment to the Constitution says that in suits at common law, you shall have a right of trial by jury should be preserved. And so what this case involved was the SEC, the Securities and Enforcement Commission, like several other agencies that we just talked about today, has enforcement actions for civil fraud via administrative proceedings, or Article 3 federal courts. And in Jercasey, the Fifth Circuit ruled in favor of the employer, which here was actually an employee, that basically said, if you proceed before an administrative law judge, that denies the accused, this here an individual, but oftentimes companies, of a constitutional right to a jury trial. And so allowing the SEC as the agency discretion to decide which forum it's going to pursue its action in, either before its own administrative law judge or a federal court, violates a constitutional non-delegation doctrine. And so that was elevated to the Supreme Court, and the Supreme Court affirmed that decision. That was an opinion, again, by Chief Justice Roberts, that basically said that SEC's anti-fraud provisions are similar to a regular common law fraud cause of action in court, and because of that, they have to be heard by a jury, according to the Seventh Amendment. And so, again, this individual was entitled to a jury trial in an Article 3 court. It's a lot of legalese and a lot of, discussion about kind of constitutional rights, but why this is so important for employers across the country is it has agency-wide effects across the federal agencies, including the National Labor Relations Board, the Department of Labor, OSHA. All of those agencies right now are facing constitutional challenges when they have tried to prosecute an unfair labor practice before an administrative law judge, or if OSHA is pursuing a whistleblower complaint before the Department of Labor's administrative scheme. Employers, just like employees, have the constitutional right to have their claims heard in federal court. And you may say, does it really matter between an administrative law judge or a federal judge? It's going to depend on the nature of your case. But the reason I'm bringing this up is for everyone to kind of just be mindful that if you do have an enforcement action from an agency, again, whether that's wage and hour division or, again, OSHA enforcement, a citation for a workplace safety issue, question or raise the query to your senior leadership. Is this something that we need to raise as a defense, that we don't need to go into the administrative law judge? We should preserve our right to a jury trial. Again, that's something to query based on the facts of your cases. But that one of the reasons why I really wanted to raise this, because it brings to focus what is happening at the federal agency level, coupled with the broader judicial trends, really curbing administrative state authority. Again, including what I talked about earlier about Chevron deference. So that may be in the weeds for a lot of you on the call, but I did want to emphasize it because it is really, I think, an increasingly legal development that we will start to see less enforcement agency action from these federal agencies and opportunities for those kinds of defenses by the business community. So with that, before I close and open the Q&A session, I just want to briefly touch on state laws. Because of this idea that there might be a curb in federal enforcement agency action, despite kind of the priorities that I talked about from the EEOC and Department of Labor previously, we are seeing that states will start to pick up where maybe the federal agency is stepping back. So be aware that if you are in other states, primarily Florida, California, Washington state, we're starting to see a number of states speak up where the federal law is silent, particularly around paid family leave. We now have 11 states, including the District of Columbia, that has a paid family leave statute where the federal law is silent, that is unpaid. The Federal Family Medical Leave Act is unpaid leave. Minnesota became the most recent state with that taking effect in 2026. Also, we're seeing, as the EEOC is pushing back on protections from the LGBTQ community, we are seeing more states step in that regard. Also, other areas of vulnerable population, child labor. Again, that's not an area of big focus from the Department of Labor right now, but I think in some states, particularly, southern states or states in the, different industries which have child labor as a source, that is an area of focus across states, and abortion as a state constitutional protection. And then in terms of worker safety, there is an increase in worker safety for state-specific plans. OSHA, only regulates about half the states, a little over half the states. We've got 22 states that are considered state plans where federal OSHA does not regulate them. So we're seeing a lot of activity in particular out of California. Cal OSHA is issuing its own regulations like heat illness. They issued a workplace violence requirement recently that every employer has to implement. So we're starting to see those kinds of areas step up, and I would expect more of that in 2026. So be mindful of what's happening at the federal level, but also don't ignore what's happening in your state or location, because that might provide more protections for your businesses than what's happening at the federal level. So with that, I wanted to make sure we at least had 10 minutes or so to answer any questions, and happy to open it up.
Thank you, Kara. That was most insightful. So with a lot of that information to unpack, we do have a few questions. Our first question is, our company has a strong culture of supporting diversity programs, including recruiting from diverse schools and training programs. Given the EEOC's recent enforcement focus, should these programs be discontinued?
Great question. I do not think that every company should pull away their DEI programs automatically. I think it is more about a strategic review of what programs you have in place, and emphasizing that if you have a strong company culture, you don't want to be changing that company culture. That could be that could be demoralizing for current employee base as well. So I think it's, rather than kind of an automatic like rip out the band-aid, this is what the government says, I think it's more a strategic alliance and strategic review of what your policies say, what do you have documented in programs, where again, does your job application say we emphasize one protected category over another? I think that is an area of focus that should be reviewed. So I don't think it's an automatic discontinue, but I do think it's a strategic realignment that focuses on your company culture, but understanding that this is where the agency is coming from, with a particular emphasis on national origin discrimination, as well as, I think, minority and people of color. So that would be my guidance, is to get the stakeholders involved and do a strategic review of your policies and procedures.
Thank you. Our next question is, given the expected increase in potential enforcement by these agencies, what should we as a company focus on early in the new year to stay ahead of compliance risks?
Yeah, I mean, one thing that I tell my clients often in January is this is the time to brush up and re-review your handbook. A lot of new laws have come into the books January 1st, particularly at the state level. So you want to make sure your policies and procedures in your employee handbook are reviewed and updated regularly. This is important because often with any type of enforcement action, definitely a union organizing or an unfair labor practice by the National Labor Relations Board, they will ask for a copy of your handbook. And if it is not compliant with their rules, that in of itself could be a separate unfair labor practice. So really constant review and updating of your employee handbook based on changes in law is really important. I think doing a payroll audit is also very important, making sure that all of your workers are properly classified as either exempt or non-exempt, that you have workers properly classified as an independent contractor in light of what we anticipate seeing from the Department of Labor, that you are paying employees properly, that you are understanding how to calculate the regular rate of pay for overtime, One of the opinion letters talked about, do you include bonuses or incentive pay in that regular rate of pay? And the answer is it depends. It depends on what type of bonus it is. And so making sure that your team really understands how to calculate those things so that you don't have what could be a pretty significant financial award and back pay in an investigation. And then, you know, again, kind of pulling on the things that I talked about with the Department of the EEOC, you know, again, reviewing job postings, reviewing employment applications, kind of just reviewing your processes in place, understanding how requests for accommodations are handled, who's responsible for that, you know, training them on those. So both the review of your policies and procedures in the handbook, as well as some training, is a good thing to focus on in the first quarter of 2026 to get you armed and ready for any potential actions later in the year.
Much appreciated. Our final question here. Our company is non-union, but as we hire workers, particularly seasonal, we are concerned that we may inadvertently hire someone with a union background. If we find ourselves in that situation, can we not hire the person or terminate the employee?
So no, you cannot do that. Being, you know, someone who has a union affiliation, that is considered a protected category. That is both, it would violate the National Labor Relations Act to take an adverse employment action against somebody who is affiliated or has worked for a union solely because of that reason. So I think one of the strategies that a lot of non-union employers use is they, you know, in the recruiting and hiring process, you know, they really closely vet those applicants and, you know, make sure that they're there to do the work that they're hired to do. Inevitably, in a highly seasonal workforce, it may be harder to do, or maybe harder to check references or verify prior employers. But I think that's important. An important step in the interview process. But certainly, to the extent that you already have an employee and you've learned after the fact that they previously worked for a unionized company, you know, I would not recommend taking any adverse employment action in that regard simply because of their union status. That would be a big no-no from the National Labor Relations Board.
Very good. Well, on behalf of AWCI, we would like to thank our presenter, Kara Maciel, and thank you, attendees, for joining us today. Have a good day, and we'll see you next time.
Thank you.